What happens when someone walks into court thinking they can outsmart the system, but the judge isn't playing along? In today's case, every word, every response, and every decision pushes things closer to a breaking point. Stay with me, because this doesn't end the way you'd expect.
Good morning. Are you Nasir Brown?
I'm not here today. Special appearance.
I'm sorry. Speak up so I can hear you.
Here today
You're appearing here today?
by special appearance.
Okay. What is your name?
I'm a third party intervener on behalf of artificial legal entity Nasir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you've now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
I have the child subject matter jurisdiction for on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
Who's this one? Upset.
Speak up so I can...
Up and down.
It's been up and down?
Yes.
Okay. So here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information, the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state
I understand. We've had this conversation before.
Conflict of interest, and for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial, and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury, and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well, okay? So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required, all right? So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I'm never been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I'm going to be able to do that.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case.
I don't know when Mr. Jeffries on my
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
It's not on my case.
Go back with the bailiff.
It's not on my case.
Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury, and we'll just get it figured out that way. All right. People come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you, the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division.
Come on, Mom. Here.
I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff.
At the end of the day, the courtroom isn't about clever words. It's about consequences. You can challenge it, resist it, even try to twist it, but the outcome will always catch up. So tell me, when reality hits, do you face it or fight a battle you were never going to win?